Okay, good afternoon, everyone. Thanks for joining us for our first Elevate HR of the year. Today we have Laura Buss, Susanna Vela, and Grant Powell from ISSS, and they are going to tell us all about the crazy things that are going on right now with immigration and give us some pointers and just get us up to speed. So I will turn it over to Laura.
Hi, thank you for having us. I'm Laura, the Assistant Director, and you will hear from Susanna, our Senior International Services Specialist and our Primary J Advisor, and Grant Powell, who works mainly with me on H-1Bs, O-1s, and permanent residency. But we're happy to be here. There are lots of updates. If you are on our listserv, you got an email earlier this week with, I think, 12 different items. We'll go over some of those in detail and can answer questions later in the presentation. So first of all, many of you know this, but International Student and Scholar Services is part of the Office of International Affairs. We are one of the consolidated units that serves both campuses. Elena C. Jones is the Associate Vice Chancellor, and underneath her, in addition to ISSS, are International Operations, International Admissions, Global Education, which is study abroad, and Marketing and Communications. Next. International Student and Scholar Services specifically serves international students, scholars, and employees on both campuses, mainly F1 students, J1 exchange visitors, H-1B and O-1 international employees, and permanent residency sponsorship based on employment. And we'll talk about each of those in more detail. But we also serve as a resource for many other immigration categories, questions, and issues that arise in the campuses. I want to start with a key concept before we launch into talking about some of the different immigration categories, because the vocabulary around this gets used in various ways that are maybe not as accurate as we would like. So an important concept in the US immigration system is the difference between visa and status. A visa is a stamp in the passport that allows someone to present themselves for entry to the United States. It's generally issued by a US consular post abroad. It doesn't determine how long someone stays, and it can expire while they're in the United States. It can also be revoked by the US Secretary of State, which we had a lot of unfortunate experience with recently, mostly with F1 students. And we're not going to talk about that experience in detail, but it really brought to light that these visas can be revoked. That's always been true, but it was done in different situations than we were used to. Status, on the other hand, is granted upon entry to the United States. Status determines how long you stay. It can be extended or changed, and it can also be violated, resulting in a loss of legal status. And the pictures here, one on the left shows the visa stamp in the passport. The one on the right shows the Form I-94, which is an arrival departure record issued by Customs and Border Protection when someone enters the United States. And so the analogy that will maybe help you remember this on the next slide is to think of the visa as the key to your apartment. It's what allows you to try and enter your apartment. It doesn't determine how long you rent that apartment, and you can lose that key or damage it, and you still have a lease. But if you exit the apartment and you need to re-enter, you have to have a key that works, or in this case, in our analogy, the visa that allows you to apply for entry. I should mention that Canadian and Bermudan citizens are exempt from visa requirements. They don't actually need a visa in their passport to enter the US. On the other hand, status is more like a lease. It determines the terms and conditions of the stay in the apartment or in the United States, including the length. And if you violate your lease, you can have negative consequences, including being evicted. Just like if you violate your immigration status, there could be negative consequences. And the most serious consequence could be deportation. So here we have a list of the most common immigration categories that we see on campus. The ones in the first section are those that require university sponsorship. F1 students, J1 exchange visitors, which includes students and the scholar categories that Susanna will talk about in detail later. International employees that we sponsor for H1B, O1, TN status, and visitors for business, B1 or WB, which is the visa waiver program. That sponsorship is minimal in the form of an invitation letter, but it still requires involvement by the university. And then we see people who are here on our campus who do not have direct sponsorship by the university. F1 students with optional practical training who are our employees. Employees or students with DACA, Deferred Action Childhood Arrival status. TPS, Temporary Protected Status. They could be students or employees or both. And dependents, J2s, H4s, L2s. People who are applicants for permanent residence and refugees and asylees. I want to give you a brief introduction to F1 students. They are coming to the United States specifically to pursue a course of study at an accredited institution. They hold F1 visas. This is specifically for academic study. And their primary purpose is education, not work, not long-term residence, not becoming a permanent resident. They have to maintain full-time enrollment and comply with all the other rules of the F1 category. They do have some limited opportunities for on-campus employment or perhaps practical training or experiential learning related to their degrees, curricular practical training, CPT, or optional practical training, OPT. There is also a subcategory in the J1 exchange visitor program for J1 students, and we do have a handful of J1 students, and this page outlines a few of the differences between them, including the home residency requirement, which applies to our J scholars also. Some people in the J1 category have a requirement to return home at the end of their J1 status. To give you some numbers on the student side, most of the international students between the two campuses are on the Denver campus. You can see a total number of 1,473. That includes students who have graduated and are F1 students on optional practical training. They're no longer enrolled. They might not even be in the Denver area, but we as a university still have responsibility for their F1 sponsorship. And you can see that big red number from China. I want to note that that includes about 550 students enrolled in the International College Beijing. That's our academic program in Beijing. So they're not in the United States, but they are our students. And you can see in the bottom there that there are 86 different nationalities represented in our student population on the Denver campus. On the Anschutz campus, we have a much smaller number of students, total of 216 from 50 countries. But this population has been growing over the last few years. And next, I will turn it over to Susanna.
Okay, great. Well, good afternoon, everyone. My name is Susanna Vela, and I will be, covering the J1 Scholars International Exchange Visitor Program, and it's commonly known as, J1 Scholars. I just would like to let you know that this program, J1 Exchange Visitors Program, is outlined in the Code of Federal Regulations in Title 22, Foreign Relations, Chapter 1, Department of State. And it was initially implemented via the Mutual Educational and Cultural Act in 1961. And then it was amended in the year of 1988. And ever since, since its establishment, the program has served as a valuable and very important, diplomatic tool of U.S. foreign policy. In relation to us, the University of Colorado Denver Anschutz, we are an official program sponsor for this, J1 sponsor or visitors program. And under the Department of State's authorization, the university can offer prospective exchange visitors paid and unpaid opportunities for research, teaching, lecturing, observation, training, or demonstrating, for instance, special skills, or including internships as well. And this is the slide where I would like to share the J1 categories that we sponsor. J1 Research Scholar, J1 Professor, J1 Short-Term Scholar, J1 Specialist, and J1 Student Intern. There's another category that I will share with you in the following slide. This slide shows a chart where you can have, or you can see, the J1 category, the common university job code, the activity, and the J length or J1 length of stay. So as you can see, the research scholar and the professor has the maximum of 5 years. And the LEM physician, which is administered by GME, Graduate of Medical Education, not by us, they're sponsored by ECFMG. They have also the longest, which is 7 years. So these two are 5 years and 7 years. What can research scholars do? Well, they can come here, right, paid or unpaid, and they can do research, observing, they can consult, and also the possibility, to teach or lecture. The professor would do the same, except the primary role is teaching. And again, they can come from 3 weeks to 5 years. Then we have the short-term scholar, also could be paid and unpaid, and they can do pretty much the same. They can come here for lecturing, consulting, training, or demonstrating, specific or special skills. The only thing is that it is up to 6 months, so it cannot be extended after 6 months. The specialists, on the other hand, also can be paid or unpaid, can also come here and observe and consult. But this category demonstrates a specific or very special knowledge. The best example I have is, let's say, a pianist, right? Because it doesn't need a bachelor's degree. It needs to show that skill. And again, it's also good up until only 1 year. Then we have the student intern. The student intern is, an undergraduate research or a trainer, and is coming here to fulfill, another objective from, the program that he or she is studying abroad. So, for example, they just come here for, to complete an internship, and then they are required to return to their home country after a year, that's the maximum, to complete their, graduate studies abroad. And then I just mentioned, the alien physicians, it is worth noting, to mention them, because even though it does not fall under our purview, we heard a lot about this, and we also receive quite a bit of emails. But again, this is sponsored by ECFMG, and then is not administered by us, it's by GME. I would like to talk to you about some of the limitations and also some of the requirements of this program, or J1 Scholars. The United States Department of State requires exchange visitors to participate remotely no more than 40%. So pretty much like all the employees, at Anschutz and, UC Denver, from what I know, no more than 40%. They may not hold tenure positions or tenure eligible faculty positions, and precisely because the spirit of the program is that to be, temporary, not in a permanent capacity. Only J1 alien physicians can have direct patient contact or patient care. And other categories cannot have direct patient contact or, patient care at all. So short-term scholars, J1 research scholars, J1 professors, J1 specialists, student interns, all of them, they can't have, patient contact or care. J1s who are employees must be paid according to university policy for their position, and employees must show a minimum amount of support as determined by ISSS. And in our case is $3,000 a month. If you have questions, you can ask me that later. And some J1 exchange visitors are required to return home for 2 years at the end of their stay, or receive a waiver before becoming eligible for some other immigration categories. That's the so-called 212E that is that is required for them to return to their home country. And the other ones are other bars, like the 12-month bar as well as the 24-month bar on repeat participation. Now let us talk about the overview of the process, the timeline, the costs for a new J1 scholar or a student intern. You may wonder what happens, what takes place first. Well, it all, takes place by you or the unit, right? The department submits or prepares, a request, a J1 request. And then the HR business partner may take 1 to 3 weeks, collecting all the documents. And it is at no cost because we don't charge, to issue the S-219s, or the university does not charge, anything to issue the S-219s. Then the second phase is when, J1 Scholars or ISSS receives that request and then reviews it. And then if it's complete, obviously, then the DS-219 is issued. And it only takes, within 10 business days after receiving that complete request. Again, it's at no cost. Then the third phase is the scholar or the student intern is when they apply for a visa and schedules or submits this visa application and schedules their interview. The consulate, varies greatly. So in other words, it might take, 1 month, it might take, longer than that, because it depends on the embassy that they chose, to have that appointment. Here is a website if you would like to check on the visa appointment wait times. And here there are some costs. There's $220 for the CIVIS, which is the system that they need to pay. It's a fee paid by the scholar or the student intern. Or sometimes, the host unit, chooses to pay that. And then we have another cost that is part of the immigration, application that they need to submit is $185, and it's called machine readable visa fee. That is paid by also, the scholar or the student, or also the host unit if the scholar or the student intern is coming from outside, the United States. And then last but not least, then we have when the scholar or student travels and arranges, the travel, buys the flight ticket, and then arrives, to, in this case, to the United States. It cannot be, they might come from New York and then finally arrive, they arrive to Colorado. And again, this also is something that it varies. Sometimes we have delays, sometimes we don't. And the cost, these travel expenses are paid again by the scholar or the student intern as well. I also would like to talk to you about other opportunities for visitors to come to the United States other than J1 scholars. And that is the United States Visa Waiver Program, which does not require a visa. So in other words, you do not have to apply, or the person does not have to apply for a visa at a U.S. embassy or consulate abroad. Instead, what they obtain is an authorization, and it's called ESTA. It's an electronic, system authorization. And with that, then they can come. However, they need to be, in the list of the countries that they have. So for example, if they're from Chile, Germany, Italy, Japan, then they might be able to use this U.S. Waiver or visa waiver program. And what it would be required from you is only a letter of invitation. Now, the visa waiver program, has some restrictions. It's only restricted to 90 days, and it cannot be extended. On the other hand, we have the so-called B1 versus, the B2 visas that I'm sure that you're very familiar with them. And these require, appointments with, a consulate, so that they need to apply for a visa abroad for them to obtain this visa. So the B2, as you can see, is merely just to go to for recreational purposes, for tourism, right? Like it says, take part in cultural events or touring different cities in the US. Also attending or receiving medical treatment or go to a family or friend event. But the B1, which is called the V1, visitors for business, they can actually use this one, these participants or international visitors, because they can come here to take part in business meetings, conventions, and exhibits, and organize also independent, research, and maybe also giving business consultations, and very important for observerships, which we have a lot of those. So the U.S. visitors visa for business, as well as the, WVP, which is the visa waiver program, they all have to have the following activities, so have to fall under these appropriate activities, both of them. And this is according to the Foreign Affairs Manual. And this document guides U.S. consular, officials, and this is what they use. So this is the appropriate use. Number one, engage in commercial transactions which do not involve gainful employment in the U.S. That's number one. Number two is negotiating contracts, consulting with business associates, litigation, participate in scientific, educational, professional, or business conventions, conferences, or seminars. This is the one that we care about because this is the one that we use. Observe, like observerships, right? Business or vocational operations. Like, for example, medical doctors, if they don't have, patient contact or care, they can come under this, the B1 as well. And then undertake independent research. The reason why I have it in red is because, it can get a little bit tricky. And according to the definition, right, to the, foreign manuals or affairs manual section 402, it has been interpreted as research that has no direct benefit to the institution where the research takes place. So in other words, there's some risk, right, that they could be denied entry if the U.S. Customs and Border Protection, the CBP officer, interprets, that research, that they're going to be doing something differently. So this is why sometimes we change gears and then, people just apply for a J1 visa instead, even though it's more laborious. What you will need in terms of what documents you need to prepare would be a letter of invitation. We have templates in our website, and I will share that later. So let us review what we went through. So we talked about the categories and the limitations of stay of the J1 scholars. The length of time that an individual may remain in the United States as a J1 exchange visitor is determined by the general limitations of each category. So the short-term scholar we mentioned is a maximum of 6 months, and they cannot extend. For the specialist would be 1 year or 12 months. For the student intern, it's a maximum of 12 months or 1 year. And for the alien physician would be a maximum of 7 years. And I skipped the research scholar, which is the most important one, and the professor, maximum of 5 years. So the duration of this J1 program is also limited also by the length of time needed to complete the program objective too. So they have to be able to, to finish or to complete that program objective. Now let us talk about and review the visitors versus, visitor for business B1 or the WV, the waiver visa program. So for the VWP, it lets citizens of participating countries travel visa-free for up to 90 days with an approved ESTA, ESTA, right? Is the electronic, system that they use, and it has to be authorized before traveling. While the B visas require a consular application. The key differences are that the visa waiver program doesn't allow extensions or change of status in the U.S. and requires pre-approval of this ESTA document. And of course, it has it's more strict because at 90 days, that's it, and they have to just return. And the B1 offers more flexibility in that capacity. Thank you very much. And now it's all over to Grant.
Thank you, Susana. Hi, everyone. I'm Grant, and I will be diving a bit deeper into our international employees and scholars. So first, we'll start here. by the numbers. So we have a list of our international employees and scholars that we sponsor. As we mentioned, this is not an exhaustive list. We have a lot of different employees in a wide array of statuses, as Laura mentioned. So that are not totally reflected in these numbers. I would imagine we have a decent number more scholars than you see here. But just kind of breaking down the numbers, we see that H-1B is the most common status, followed by J-1, and then O-1 being the least common. And then Anschutz hosts the majority of our international employees and scholars because ISSS is a dual campus unit. We also work with scholars from the Denver campus, but the majority of our time is spent with Anschutz employees. Next slide, please. So H-1B, the infamous H-1B, I'm sure many of you have worked with us on incoming scholars or employees wanting to obtain H-1B status. So the H-1B classification, by far the most common on campus that I work with and Laura works with. H-1Bs are non-immigrant visas that are used by the university to hire international employees in a specialty occupation for a maximum of 6 years. And generally, they can be extended to up to 3 years at a time in 3-year increments. Extensions beyond the 6-year maximum are possible if certain deadlines are met in the permanent residency process. But I will get into more detail on that in a little bit. So on the left-hand side, we have a chart of some, no, same slide, Susanna. So on the H-1B, we have a chart of sample job titles and job categories for H-1B. This is not an exhaustive list, but these are pretty common titles and categories that we see. As you can see, there are people in H1 with H-1Bs from staff to postdocs to professors, and that's kind of why it's important to understand what a specialty occupation is. So over there on the right, we have the definition of that. And the specialty occupation, so for a position to be H-1B eligible, it has to meet the qualifications or qualifications of a specialty occupation, which is super important, especially when we get into the realm of like staff appointments and things like that, to make sure that that job and that employee are eligible for H-1B status. So what is a specialty occupation? It is a position that requires two different things. So the first is a theoretical and practical application of a body of highly specialized knowledge and the attainment of a bachelor's degree or higher in the specific specialty or its equivalent. So equivalent would be like, a UK equivalent of a bachelor's degree in the US. Regarding the timeline on H-1Bs, when to submit the request to ISSS, we highly recommend submitting the H-1B request form, which is linked in the slides. So I'm not sure if we're sharing those, but it's on the ISSS website. 6 to 8 months in advance before the proposed start date. This really gives us time to review the request, address any potential issues. And additionally, the earliest we're able to file an H-1B and the I-129 petition is 6 months before the proposed start date. So that 8 months, that gives us, say it's at 8 months, that really gives us some time to review everything and then get that in as soon as possible, especially with everything going on right now. It's good to get that in as early as we can. I would say the absolute latest we'd want an H-1B request would be 2 months before the proposed start date. That's 2 months is about how long it would take us in the law firm to prepare and submit the petition. And say in the case of 2 months, we would definitely need premium processing so we could get that international employee in on time for their start date. So O1s, as I mentioned, much less common at the university, although we do have people on O1s at Anschutz, specifically in relation to H1 or H1B and J1, minuscule numbers. We only have a few, as you saw on the previous slide. So O1s are for people with extraordinary ability in the arts, sciences, education, business, athletics, and To become eligible for an O1, you must have sustained national or international acclaim. Often this means you're at the very top percentage of your field, in the field that you work, published a lot of papers, given a lot of lectures, a lot of conferences attended, things like that. It's we have to prove that this person really is the kind of a big deal if we bring them in on an O1. And so on the right-hand side, you can see the two different types of O1 categories and the basis for classification. There are O1As and O1Bs. The university would really only ever bring someone in on an O1A, since, as you can see, O1B is for arts, motion picture, movies, TV, whatever, and that's not super relevant to a medical campus. Additionally, O1 petitions incur higher costs for the university, since the petition itself costs more to prepare and file. And additionally, most O1s are only able to be extended in 1-year increments after that first initial 3 years. So long term, this can really inflate the costs of bringing someone in on an O1, and that's especially compared to J1s and H1Bs. As for the timeline, like H1Bs, we encourage submission of the O1 request form as early as possible. 6-8 months in advance would be ideal. O1 petitions can take a lot longer to prepare, just depending, on how much we need to prove, because we do have to prove to the government that the person that we're bringing in on this O1 is indeed extraordinary and one of the best in their field. Unlike H1Bs, though, we don't need to wait until 6 months before the proposed start date to file that O1 petition. So if you want to give us a request a year in advance, we could file that in theory a year in advance before the start date, and just get that in. That wouldn't probably be necessary, but in theory that could happen.
Grant, I'll just add a couple of examples of when we use the O1. Because the H1B is easier and less expensive, we try and use it, but occasionally we'll have someone who was previously a J1 and is subject to the 2-year home residency requirement, which prohibits them from changing status to H1B or even applying for an H1B visa abroad. There's an exception, someone who is subject to the 2-year home residency requirement from previous J sponsorship can leave the United States with an approved O1 petition, apply for the O1 visa, and re-enter. So those are the instances where we use it when someone's not eligible for the J. It might be someone who was a Fulbright scholar in a J in the past. It might be someone who was a J1 medical resident or fellow, and they're subject to the 2-year home residency requirement because of the medical training. We do anticipate perhaps seeing a few more of these coming up for people who are overseas and we want to bring in, who as an H1B would be subject to the $100,000 fee, which we will talk about in a little bit. But that's why there are so few of them, but it is a really helpful category in certain circumstances.
Perfect. And then we'll get more into, and one thing I did want to mention too, kind of piggybacking off what Laura said, we have had instances where we brought someone in as an O1 and then had them change status to H1B. That can kind of keep costs down in the long term. But anyway, we'll talk about, dive deeper a bit into other categories. I know Laura mentioned a lot of these earlier. But we have international employees in a plethora of statuses at the university: TN, OPT, L2H4, TPS, DACA, etc. And generally, ISSS doesn't have as much info on these employees, in these types of statuses, since we are not typically the ones sponsoring these petitions. But it's good to be aware of what these statuses are, who they are, and that we have these employees in these statuses nonetheless. So TNs were established by the North American Free Trade Agreement, also called NAFTA, which was renegotiated to be now called the USMCA, excuse me. And TNs are for Canadian and Mexican citizens only. No one else is able to apply for TN or be in TN status. To work on a TN in the US, the beneficiary must have secured a job in a designated TN profession before applying for TN status. And there are regulations, kind of like H-1B specialty occupation, that list out, you know, what's TN eligible and what's not. Like H-1Bs, TN visas can be extended for up to 3 years at a time, but there's no limit on the number of renewals as long as that employment remains temporary. And then optional practical training, I'm sure many of you have at least heard of or are familiar with. OPT is a benefit for F1 students to work in their field of study in the US after graduation. And post-completion OPT is available to pretty much all F1 students and allows them to work for 1 year after graduation. STEM OPT is available to students who graduated with degrees in STEM fields, and that allows them to extend their OPT period for an additional 2 years after that initial 1 year of post-completion OPT. So if someone's on STEM OPT for the university, they would have a max 2 years, but the full OPT period could potentially be 3 years if they qualify for that STEM extension. And then lastly, we have other much less common categories that we see at the university. Like L2, for example, would be dependents of L1 status holders. H4s would be dependents of typically H1B status holders. And then much less common statuses like DACA and TPS, which temporary protected status, also exist on campus. But just to go over, to echo that we don't really have, we're not involved in these petitions typically. And so we don't have much data or information on people who hold these statuses. All right, to lawful permanent residency. So this is an option for many of our international employees with the department's support. Someone, you know, a department sponsoring someone for permanent residency is by no means mandatory, but it is an option to keep someone here long-term with the department's support. So there are 2 relevant pathways, really kind of like overarching pathways to permanent residency, those being employment-based and family-based. So employment-based would be obtaining permanent residency through employment, unsurprisingly, which is what our office, ISSS, would help with. While family-based would be obtaining permanent residency through marriage to a US citizen, and our office, the university, would have no involvement with the family-based process until they receive their legal permanent residency card, at which point we would update their status with HR I-9 and international tax. So on the left-hand side, we have another chart kind of outlining the employment-based categories that we sponsor for our international employees and the basis for classification for each of those. There are 2 other EB categories, which would be EB4 and EB5, but those aren't relevant to LPR sponsorship with us. I think one's an investor and one's an unskilled worker or something like that, so that wouldn't be applicable. But I will kind of highlight the 3, EB1, EB2, EB3, the 3 kind of categories that we see often at the university. So the EB1 basis for classification, either alien of extraordinary ability, which would be EB1A, or outstanding professor or researcher, which would be EB1B. International employees are able to self-petition for EB1A, but EB1Bs must be employer petitioned. The EB2 category, the basis for classification, advanced degree professional with specialized expertise using either a labor certification or national interest waiver. Those 2 terms probably sound familiar for those of you who work pretty closely with ISSS. With the labor certification, what that does is essentially test the labor market to ensure no qualified US workers are available. And once that test period is complete, we can apply for permanent residency on behalf of the international employee. Whereas national interest waivers kind of a similar, longer process. It has a strict, three-pronged criteria, which I won't get into because that's really getting in the weeds of it. But just know that both labor certifications and national interest waivers can be very intensive, labor intensive, EB2 pathways, and they can take a decent amount of time. And then lastly, we have the EB3 category, basis for classification, either professionals or skilled workers, and these may often require labor certification. We wouldn't file an I-140 petition for an unskilled worker, which you can see down at the bottom. But the professional or skilled worker classifications come with considerations like minimum education, the experience required, and the skills required. One last note I would say about these three categories is that hiring units don't really need to know the exact category and basis for classification when submitting a permanent residency request to us. We, the ISSS, will work with the law firm to find the best pathway for each request we receive. And so in terms of eligibility for permanent resident or for permanent residency, only employees with quote unquote permanent positions and a feasible pathway are able to apply for permanent residency. So for example, term limited positions like fellows and postdocs cannot apply for permanent residency. If we get them into a assistant professor role after their postdoc or something, then absolutely. But those, those temporary employment positions, we aren't able to sponsor. And then so for the timeline, like everything else, we encourage hiring units to start thinking about permanent residency early on, when we've hired that international employee and they're in the US, and we encourage hiring units to submit the LPR request form as early as possible. As I mentioned, the LPR process, especially labor certifications and national interest waivers, can take multiple years and can be very labor intensive. So it's good to at least start thinking about it early. I know Laura will often follow up with departments and see what they're thinking, not long after that new employee gets in the country. And then many of our LPR candidates, just one thing I wanted to note kind of in relation to H-1Bs. So many of them are H-1B status holders, if not almost all of them. And as I mentioned, H-1Bs have a 6-year time limit. So we can extend that 6-year time limit, or we can extend, an H-1B status beyond the 6-year time limit under 2 different circumstances. So we're able to extend in 1-year increments if we have filed a labor certification, and that certification has been pending for 365 days or more, or if we filed an I-140 petition and that's been pending for 1 year or more. And then the other way that we can extend beyond the 3 years would be a 3-year extension if an employee has an approved I-140 but is unable to adjust their status to permanent residency. That could be for reasons such as the per country visa limits that we have when people adjust to permanent residence. And the immigration roadmap. So on the right-hand side, you will see a very confusing and complicated graphic that is impossible to read. I think that's a great kind of visualization of the U.S. immigration system, because the U.S. immigration system is complicated and hard to read and daunting, and it's hard to follow. So as you can see, there's not really one set path to becoming a permanent resident and or citizen. There are a lot of different ways that international employees or just populations more generally can take to work their way through the immigration system. And on the left-hand side, I've highlighted a few that we see at the university, and I'll get into those a bit. So the first one, F1 to H1B to LPR. So one common route that we see is F1 students, either on OPT or semi-OPT, they'll change status to H1B. These F1 students they're often already in the US and sometimes are employed with the university, but they don't necessarily have to be employed with the university for them to change status to H1B. Once that F1 student becomes an H1B, we can submit an I-140 petition for them to become a permanent resident with their department support. The caveat to this, as I've mentioned, is that if they're in a postdoc or any sort of temporary position, we can't sponsor that for permanent residency. Another one we see would be J1 to H1B to LPR. So when a J1 scholar, if they change their status to H1B, they're able to do that in some cases. If they're subject to the 212E 2-year home residency requirement, which I know Susanna mentioned, that would require a J1 waiver. Not all the time is that necessary, but that does happen a lot. This is a little less common, I would say, than maybe the OPT to H1B pathway. But once someone is in H1B status with their department support, we can file an I-140 petition for them to become a permanent resident. And then lastly, like everything with O1s, this is the least common pathway that we would see at the university, going from O1 to permanent resident. So often, one thing I want to highlight about like this pathway would be that F1 students on OPT or some OPT almost certainly wouldn't qualify for an O1, because O1 petitions need to demonstrate that the beneficiary is one of the best people in the country or in the world in their field. And because of this, O1s are either usually hired from abroad or from another institution in the US. But once that O1 employee, they're in O1 status with the university, we can file that I-140 petition for them with the department's support. And then, as I kind of mentioned earlier, in some cases, we may be able to bring someone here on an O1 to get them in and then have them change status to H1B, at which point we could file a I-140 permanent residency petition. Again, that's also not very common. But yeah, so those are some of the common paths that we could see, and a visual of the current state of things in the US immigration system for you.
Okay, so after all of that, you can see that hiring international employees involves a certain amount of work, consideration, and cost. So why do people do it? As a world-class institution, we're seeking the best staff available to support our missions of education, research, medical care, and often the best person available might be an international applicant. And we weigh that against being a public institution that supports and contributes to our state in many ways, including local employment, and also weigh it against immigration sponsorship, which involves costs and administrative burden, and also some risks. So as you're considering whether this is something that you as a hiring unit want to do, you can in the posting indicate that immigration sponsorship is not offered if you've determined that it's not possible for that particular position, either because it doesn't meet the requirements, for example, of an H-1B, or because the financial burden is too high. We also, with the $100,000 fee, again, I'll talk about it in a little bit more detail in a moment, H-1B sponsorship might be something you're interested in, but you can't do it if the $100,000 fee is possible or is required. And there are questions on the CU application regarding employment authorization and immigration sponsorship. So you do have a bit of information at the start of a search as to whether someone currently has employment authorization or if they will now or in the future need immigration sponsorship. In terms of onboarding and the process, we've talked about the different processes depending on what the most appropriate immigration category is. But there are some resources on the HR website under hiring process and onboarding for all employee categories. There are some specific documents related to international employees about export control, which I didn't include here, but they are there. A guide to hiring international applicants, which has some information about when and how to ask about immigration status and sponsorship beyond what you see on the application. And also occasionally for our current employees, they run into immigration-related gaps in work authorization, and there's some guidance there about what can happen in that situation. ISSS can also provide optional language for the letter of offer about it being contingent on employment authorization and about immigration sponsorship. Also part of the onboarding and places where ISSS has some interaction but not responsibility. Anyone who's not a US citizen or permanent resident should be familiar with international tax. They help international employees meet payroll and tax obligations, and international employees should complete an online tax profile. This allows their tax withholding to be as accurate as possible, and it triggers a data feed from HCM to ISSS. International tax is the one who can complete those fields in HCM. And when certain fields in HCM are completed by international tax, it triggers a data feed to ISSS. That data feed is really important to us because then we can monitor changes in employment, changes in position that might affect the H-1B authorization, a termination, which also requires action on our part. So we work with international tax, and international tax has access to our system to identify people who haven't met with them and try and get that process completed to help everyone. We also work closely with HR I-9. First of all of you are more familiar with that because you work with HR I-9 to complete the I-9s. And HR I-9 I-9s are different for international employees in that they can expire and have to be renewed, and HR I-9 monitors those dates and sends reminders. And when ISSS, representing the university sponsorship for someone's immigration status, we notify HR I-9 if someone's status changes or is extended, because that can affect the I-9. As for the Social Security number, someone can start work without a Social Security number, and they can only apply for it after they've arrived in the United States. And this is necessary for the university to report taxes at the end of the year, but there may be some other internal deadlines. We advise people on how to apply for the Social Security number, but ISSS doesn't have any involvement beyond that. And then to the next screen or slide, ISSS has an updates page, and we post all kinds of updates here of the most impactful changes in the immigration world. So here I've listed some of the most recent ones. In December, the US Department of State began vetting and reviewing the social media of anyone who applies for an H-1B or an H-4 visa abroad. And the result of that was cancellation of many visa appointments across the world, mostly in India. So some people are now stuck while they wait for a new visa appointment. I haven't gotten a report from any H-1B employee that happened to them. We did have one employee who found out about the cancellation before she left, so she canceled her trip. We've heard about other delays from other H-1B employees who went home over the holidays, and the delays have ranged from 1 day to 2 weeks. I think one person is still waiting. So that has an impact on future travel for our employees. If they want to travel for personal or professional reasons and they need to apply for a new visa, they'll have to take into account a longer period of time to get that visa. In December, some countries were added to the presidential proclamation about entry restrictions for people from certain countries. There are countries that have total bans and some that have partial bans, and some countries were added. Because this is an entry restriction, it only applies when people are outside the United States and need to come in. But in conjunction with that, USCIS announced that they will pause processing on petitions and applications from people from these countries for additional review. So we've already seen a request for evidence on one H-1B for someone who is from a country named in that presidential proclamation. And we expect it on a few other applications that we have pending, and perhaps future applications that we'll need to file on behalf of employees from those named countries. And now to the infamous $100,000 fee. This was inspired a lot of panic when it was announced. Once the US government clarified what they really meant, the impact was far less. I was sitting at the airport leaving on a trip abroad when Grant was frantically texting me because it was a Friday afternoon when this was announced. And I'm so grateful to Grant and our director, Michelle Larson-Krieg, and others who stepped in as all of this was happening.
That was an interesting Friday night, I will say.
Yeah. So again, after the clarifications, this affects a much smaller population than initially thought. That $100,000 fee only applies when someone is outside the United States and needs to apply for an H-1B visa and enter the United States on a new initial H-1B. It doesn't apply to our current employees who travel, our current employees who need extensions or amendments, our current employees who need a change of status to H-1B, or any new employee that needs a change of status to H-1B, or who is already an H-1B and is changing H-1B employers. So the impact is limited, but it is still there. Some offers have been withdrawn because I'm assuming most departments cannot pay the $100,000 fee. There is an exception to the fee called a national interest exception. And although USCIS offered a way to ask for this exception, it seems that they are not responding to employer requests for it. We ourselves have one that's been pending since October. So it is not currently a feasible option to request a national interest exception in order to bring someone in from outside the United States. And this is why we anticipate a few more O1 applications coming up, because there will be some people who are not eligible for the H-1B without the $100,000 fee, but perhaps they meet the criteria for the O1. The US Department of State announced a requirement that everyone has to apply for a visa in their home country, either their country of citizenship or their country of residence. In the past, someone could go to a country that's not their own to apply for a visa, and that's no longer possible. And this is most relevant to people who were traveling perhaps to a professional conference and needed a visa, and they would apply where the conference was held and not their home country. That is no longer possible. Last fall, the US Department of Homeland Security issued proposed regulations to eliminate duration of status for F students and J1 exchange visitors. Unlike other immigration categories, F1 and J1s are given duration of status. It means that they are allowed to stay in the United States for the time it takes to complete their program. That involves, for example, maintaining full-time enrollment as an F1 student, or a J1 postdoc maintaining their position. And that period of time is defined by the date on their I-20 or their DS 2019. And ISSS can extend the I-20 or the DS 2019. We do expect the final rule sometime this spring. And if it's finalized as it was proposed, it means that ISSS can no longer process extensions for F1 students or J1 exchange visitors. When they enter the United States, they will be given the period of time predicted to complete their program. So for example, 4 years for a bachelor's degree or a 3-year postdoc, up to a maximum of 4 years. And anyone who needs an extension of that original time period will have to apply to USCIS and pay the filing fee. There are a lot more things on our update page, including how to hiring an immigration attorney, the documents that we recommend everyone carry in the United States, how to create an emergency action plan, and an international travel worksheet, because people, of course, want to travel. They want to go home. They have professional reasons to travel, but there are increased risks. And we advise everyone to carefully evaluate their individual risk for travel and also their risk tolerance. Here's our contact information. As a consolidated unit, we do maintain offices on both campuses. On the Anschutz campus, we are in the Fitzsimmons building, and an ISSS staff person is there every day but Tuesdays, which is the day we're all required to be on the Denver campus. Susanna, Grant, or I are there on one of those days, and sometimes it's more than us. On the Denver campus, our main administrative office is located in the Lawrence Street Center, and we also have an office in Student Commons where most of the F1 students come for help. We have 3 email addresses, and you can get a quicker response to your question if you choose the right email address. The ISSS email address is for F1 and J1 students enrolled in programs on our campus. Susanna has one for J1 scholars specifically, and then Grant and I monitor the employment-based immigration email, which is for H-1B, O-1, LPR, and any other question you have. We also have information on our website, and we have a link there to make appointments with us. And I will share these slides with Deanna. She can share them with the rest of you. And after all of that, we have time for questions. You can unmute and ask.
Thank you so much for this presentation, you guys. Yeah, so anybody have specific questions? Go ahead and ask. You can come off mute and just ask your question.
Hey Laura, Thomas from Ortho here. I had a question, and I apologize in advance if any of these are stuff that you went over. This has been a real like drinking from the fire hose meeting for me. But I just want to get clarification one more time on the 212 home residency requirement, because when I process J1s, that always comes up, and I want to make sure I have a total understanding of it.
So because the exchange visitor program was created as an exchange and a tool of soft power and diplomacy, as Susanna said, there is a requirement for some people to go home for a period of 2 years, because the idea is they come here for training, study, other reasons, and then they return home with that knowledge and experience. So I'll talk about physicians first. Anyone who participates in medical training as a J1 sponsored by ECFMG is subject to the 2-year home residency requirement across the board. And the most common way that we get involved with that is if they are hired for a position here at the university, not a medical training position, but a full-time position such as assistant professor, and they will be providing clinical care, patient care, we can sponsor them for a Conrad waiver of the 2-year home residency requirement, and that allows them to become an H-1B and start their medical career in the United States. For the people who come in as J1 research scholars, our other most common use of the J1 category, people from certain countries and in certain fields can be subject to the 2-year home residency requirement. There was a revision to that requirement a couple of years ago, which actually eliminated a lot of people from being subject. And then if someone has government funding, either US government funding or home government funding, they are subject to that requirement. A good example on the US funding side would be someone who has a Fulbright scholarship and comes to the United States to study. And home country government funding could range a variety of different sources. And if they are subject to that 2-year home residency requirement, they cannot change status to H-1B in the US. They can't go abroad and get an H-1B visa. The only exception to that is Canadian citizens. There's a loophole. that allows it for them. And there are ways to waive the 2-year home residency requirement outside of the Conrad waiver for ECFMG sponsored positions. There's an extreme hardship. Extreme is in the word, it's extremely hard to get, but that is an option. A more common way to waive the 2-year home residency requirement is called a no objection statement, where the home country issues a statement saying they don't object to a waiver, and then the US evaluates its interest. And if both parties agree, a waiver can be granted, and that paves the way for someone to become an H-1B, to eventually become a permanent resident. I mentioned earlier that one of the scenarios in which we use the O1, is when someone is subject and they're either not eligible for a waiver or they're in the process and we need something to bridge the gap. Does that cover it? We do have a page on our website about the 2-year home residency requirement, and I can put that in the chat.
That is very thorough and helpful. Thank you.
Great. Any other questions?
Going once, going twice.
Well, thank you so much. We appreciate the partnership with all of the HR business partners. None of this could happen without you supporting your departments and international employees. And, the one piece we didn't talk about, which I think many of you know, is that although ISSS manages this process, we do not, for the H-1Bs, O-1s, and permanent residency, actually prepare and file the petition. That is done by the law firms that are authorized by the system to represent our campuses. So, of course, we have a very close partnership with them, and you communicate directly with them too. We have Deborah Schneider at Frederickson and Byron, and Jake Panusek at Ogletree and Deacons, which does most of the case on the Denver campus, but also does labor certifications for the Anschutz campus. And thanks again for the opportunity to talk with you. There are a lot of things in play and a lot of things changing, and we'll try to keep you up to date. It is definitely keeping us on our toes.
All right. Well, thanks everybody for joining us today. Next month, we are going to have a discussion around compensation, salary setting, and we're going to get a preview of Anaplan from the budget office. So for those of you who are involved with the labor planning process, we're going to get a little insight into that. So we'll see you next month. Thanks again.
Thank you, everyone. Bye.